One of our clients, a relatively large condominium association, had an issue with its managing agent. I received a call on a Friday afternoon, and basically the treasurer was in a panic. He said there was some money missing from their bank accounts, actually a substantial sum, somewhere in the tune of $200,000, and he couldn't offer any explanation. He couldn't get the managing agent on the phone. I made some calls to the managing agent. We weren't getting any kind of proper response, and we came to the conclusion that something funny might be going on. So we contacted the bank, and sure enough, it turned out that large sums of money had been withdrawn by the managing agent, and as I mentioned, we couldn't get any kind of response from the managing agent. So we concluded that something bad had happened, and it's possible that the managing agent was actually stealing. This turned out to be true. We haven't got any criminal conviction against the managing agent yet, but we're pursuing that. But what was more problematic at the moment was preventing the managing agent from taking any additional funds once we realized that something was wrong. And also, we discovered that the building's electricity hadn't been paid in months, and that a shutoff was imminent. So we had to spring into action. We had to get the association's accounts frozen from the managing agent, and also enable the treasurer and other board members to access the accounts because they weren't on signatory cards. So I guess the lesson there is to make sure that you're on your signatory cards for your bank accounts. We did get things worked out with the utility provider after filing an injunction. So that issue was resolved, and then we had to go about collecting the money from the managing agent because they clearly had taken the funds. We had to make a decision whether to go after them criminally or civilly.
There are several lessons to be learned from what occurred here. The first, I suppose, would be that you should consider all of your options when something like this does occur, and not necessarily resort to one option over the other because it seems like it's the obvious choice. For instance, you may not want to seek government intervention through the police or otherwise, as the subjects of the investigation would conceivably take the Fifth Amendment and begin to not cooperate, and the government's interest would be to exact criminal penalties and not to recover your funds. The key focus really should be, or at least to be considered, would be notice to an insurance company, all of the insurance companies, yours as well as the management companies, especially if there is crime or dishonesty coverage. But even if there isn't, that would be one of the first things you would do. And you should also consider whether or not it's appropriate to seek the government's intervention, as it may be easier for you to recover the funds or to secure and protect your rights by going through the civil process. The second lesson, I suppose, would be that a lot of this can be not necessarily prevented, but at least the chance of it be lessened by doing things prior to it occurring, obviously. Making sure that you have the proper insurance coverages, which would be crime and dishonesty coverage, making sure your management company does have such coverages as well. Making sure that there is joint access to funds, not just management company access, of course not just board member access as well, but some joint control, some joint access that would prevent this kind of thing from happening. And then making sure that you're getting regular reporting, regular financial records from your management company, perhaps monthly, if not otherwise, but at least monthly. Obviously, if you're a layman, it may be difficult for you to determine from the records that you get whether or not there has been some untoward conduct. But certainly the absence of the records and the management company's inability to provide them to you is pretty obviously a red flag, or could be a red flag.